I'm Politico's Eastern Mediterranean correspondent. I'm also the Deputy Editor-in-Chief in Kathimerini English edition. And I would like to thank Cyprus Forum for giving me the opportunity to moderate this very interesting and yet again very timely panel on migration, on this complex issue that is always on top of the political agenda in Europe. We have several developments in the last weeks and months. We're going to discuss this complex issue all around Europe with a focus on Cyprus. We're going to discuss border technologies. We're going to discuss migration policies. We will unpack Germany's recent announcement on migration policy and how this affects the rest of Europe. And we're also going to explore legal issues that arise when migrants are found at sea, considering the state's sovereign right to protect its borders, while at the same time adhering to national laws, EU laws, international law, and the provisions under the international law of the sea. With me, I have a panel of distinguished guests. Dr. Nikolaos Ioannides, who is the Deputy Minister of Migration and International Protection of Cyprus. Mrs. Maria Stylianou-Lottides, who is the Ombudsperson for the Republic of Cyprus. We have via Zoom Mrs. Maria Gavouneli. Thank you very much for joining us. She's the Director General at ELIAMEP and Professor of International Law, and she's also the President of the Greek National Commission for Human Rights. Mrs. Aphrodite Papachristodoulou is the legal researcher and part-time lecturer at the University of Galway. And Mr. Efthymios Papastavridis is researcher and teaching associate at the University of Athens. We will start with two keynote speeches. First, Mr. Nikolaos Ioannides. Thank you.
In many respects, we live in an era of uncertainty in terms of migration concerning both our region and the entire globe. Therefore, even though the numbers of irregular arrivals have decreased significantly owing to the measures this government has taken, managing migration in Cyprus has never been more challenging. Among the 27 European Union member states, Cyprus has the highest number of first-time applications for international protection in proportion to its population. The percentage of applicants and beneficiaries of international protection in Cyprus corresponds now to 6% of the country's population. This is because there are several factors generating unique conditions conducive to regular migration. Cyprus is a frontline state in close proximity to the turbulent Middle East region. At the same time, the northern part of our island is under belligerent occupation by Turkey, and consequently, Cyprus is divided by the so-called Green Line. Migrant flows from Turkey into the occupied areas and subsequently into the government-controlled areas via the Green Line renders efficient monitoring of the line indispensable. Of course, the Green Line is not and shall never become an external border of the Republic. In light of this, we have been utilizing resources and human power in order to achieve effective management of disproportionate migratory pressures that our country has been facing in the last years. With a view to handling the ongoing crisis, the Republic of Cyprus has adopted a number of measures, such as surveillance along the Green Line, so as to limit the flows from the occupied areas, according to the obligation of the Republic of Cyprus by virtue of Article 3 of the Green Line regulation. Nonetheless, this unfortunate situation deriving from the unlawful Turkish occupation of northern Cyprus facilitates human trafficking and migrant smuggling. Against this backdrop, and always in conformity with our obligations under international and European law, the government of Cyprus cannot allow the normalization of irregular crossings through the Green Line. If this new route is normalized, criminal networks will increasingly use this passage to smuggle thousands of irregular migrants into Cyprus. In this regard, our government is determined to dismantle such criminal networks that exploit the human need and pain. As I mentioned earlier, the Green Line is not a border nor a transit zone. It is a sui generis and unique situation where special EU rules apply according to the Green Line regulation. Hence, crossings are governed by the provisions of this regulation, which envisages crossings by third country nationals only when the following two conditions are met. They possess either a residence permit issued by the Republic of Cyprus or a valid travel document or a valid visa, and they do not represent a threat to public safety. At the same time, we call for the full implementation of the EU-Turkey Statement and the EU Readmission Agreement in order to curb the arrivals and migrant flows from Turkey into Cyprus and the EU. Additionally, within the context of migration management, the government of the Republic of Cyprus decided to temporarily suspend the examination of applications for international protection submitted by Syrian nationals. It should be clarified that what has been suspended is the examination of application, not their submission. Meanwhile, Syrian applicants enjoy all the rights provided for under the refugee law, such as access to education, healthcare, labour market. It should also be stressed that the Republic of Cyprus supports the commencement of an internal EU discussion concerning the overall stance of the Union vis-à-vis Syria. Furthermore, the government of the Republic has sought the strengthening of cooperation with Lebanon. This approach has led to the cessation of departures of vessels carrying irregular migrants to Cyprus, the exchange of information with the Lebanese authorities with a view to identifying and arresting smugglers, as well as a collaboration on the surveillance of maritime borders. Moreover, the Republic performs naval patrols outside the Republic's territorial sea. These patrols are carried out in compliance with international law, the law of the sea, and human rights. The fact that no search and rescue incidents have occurred since the commencement of the aforementioned patrols is a testament to this. It should also be mentioned that over the last 10 years, the Republic has granted international protection to 18,000 individuals. Therefore, Cyprus respects human rights and abides by its obligations. The statistical data prove exactly that. Nevertheless, it is necessary to stem migrant flows in order to maintain a viable asylum system in Cyprus. What is more, reduced flows over the last months provide us with an opportunity to expedite the examination of pending asylum applications, 22,000 at the moment, and to improve our infrastructure so as to ensure humane conditions for asylum seekers. In addition, we place particular emphasis on the integration of those who are entitled to remain in the Republic. To this effect, we've been working on a comprehensive strategy with a view to avoiding the creation of ghettos and the marginalization of migrants. At the same time, Cyprus performs organized repatriation operations in order to make sure that those who have no right to stay in the Republic can return to their home country safely and with dignity. Reference should also be made to the adoption of the European Pact on Migration and Asylum, which strikes a balance between responsibility and effective solidarity. It is also important to note that the Pact reflects the need for both external border control and a solidarity scheme. Without concrete support and real acts of solidarity by our European counterparts, we will no longer be able to handle massive migrant flows alone. To conclude, I would like to stress that our successful migration policy encourages us to be even more assertive of our national interests in managing the clearly disproportionate migratory flows. Nevertheless, we remain committed to international law and the EU acquis without overlooking the humanitarian aspect of migration. Thank you.
And now Mrs. Lottides for her keynote speech.
Prime Minister, ladies and gentlemen, esteemed guests. It is with pleasure that I'm here today, and I would particularly like to thank the organizers for giving me the opportunity to participate in this forum. It is important to stress from the beginning that irrespective of the irregularity related to the migration status of persons, the need to respect their human rights are indisputable. Having said that, it is crucial to also acknowledge that there are also occasions where other circumstances should or ought to be taken into consideration by the authorities when deciding the relevant matter. Irregular migration and the need to respect and protect human rights is both a complex and deeply human matter. One could also argue that it is a global challenge, and in this challenge, the Ombudsman institution plays a crucial role in ensuring that human rights are respected. Migration is not a new subject in human history. Throughout the centuries, people have moved seeking better opportunities, fleeing persecution, or simply in search of survival. However, in today's world, where borders are more rigid and geopolitical tensions are higher, we have seen the rise of irregular migration, the movement of people outside the frameworks of legal and formal migration channels, or even people who initially entered and reside in a country on legal terms, but eventually find themselves in an irregular state for specific reasons. This phenomenon brings with it both humanitarian crises and political challenges. In every case, the principle of the issue remains. Every person, regardless of their legal status, is entitled to fundamental human rights. It is important to remember that irregular migration is not a monolithic issue. People undertake dangerous journeys for many reasons. Some flee war zones in places like Syria, Afghanistan, Sudan, and now Lebanon. Others escape economic despair, seeking to lift their families out of poverty, and some are victims of human trafficking or exploitation, forced into movement by the most nefarious of circumstances. Many of these, who we sometimes call irregular because they have crossed borders without proper documentation, are not acting out of criminal intent but out of desperation. They are mothers and fathers, children and elderly, seeking safety and dignity. Yet, far too often they find themselves trapped in limbo, facing detention, discrimination, and even violence. When considering the humanitarian dimension of this issue, we must take into account the fact that tens of thousands of migrants die or go missing every year trying to cross dangerous terrains, including the Mediterranean Sea. These numbers present something more than statistics. They are individual stories of lost potential, shattered dreams, and families torn apart. Moreover, those who survive often face inhuman conditions in detention centers, whereas women and children, in particular, are vulnerable to abuse and exploitation, both on the journey and upon arrival in host countries. Without a doubt, at the core of our response to this crisis must be the protection of human rights. Irregular migrants are human beings deserving of dignity, respect, and protection. This is not just a moral imperative, but also a legal one, enshrined in international law. The Universal Declaration of Human Rights, the International Covenant of Civil and Political Rights, and many other treaties assert that all individuals, no matter their status, have the right to life, liberty, and security. But too often, when we talk about migration, the conversation centers around security, securing borders, enforcing laws, and controlling populations. While these are important aspects of national sovereignty, we cannot allow them to overshadow the basic rights of individuals. Nations have the sovereign right to protect their borders and regulate the flow of people. National security, economic stability, and the welfare of citizens are legitimate concerns for any state. Every country is entitled to control who enters and resides in its territory and to ensure the safety and well-being of its population. However, border protection and human rights are not mutually exclusive. A humane and effective approach to migration management requires policies that respect the rule of law while safeguarding the dignity of migrants. While it is essential to prevent human trafficking, drug smuggling, and other illegal activities, we must ensure that border control measures do not lead to the criminalization of vulnerable individuals or the violation of their basic rights. Too often, we witness migrants being detained in deplorable conditions, families being separated, and individuals being denied access to asylum procedures. This brings us to the method of pushbacks, which is the forcible return of people across international borders without an assessment of their rights to seek asylum or other protection, a practice which raises serious issues in terms of human rights violations and should in any case be avoided, as the application of such a practice constitutes a form of torture or ill treatment or possible violation of the right to life. This is not the solution. Instead, we must focus on strengthening legal pathways for migration, improving coordination between states, and investing in infrastructure that supports both migrants and border security personnel. In a recent decision, the European Court of Human Rights reiterated the obligation of each member state to ensure access to its territory to any person seeking international protection, claiming that in the event of his return to the country from which he came from, his safety may be compromised, since such a practice will expose the person in question to risk of ill treatment or degrading inhumane treatment, in particular in case of a refusal to thoroughly examine the personal circumstances and the alleged allegations of each applicant. At the same time, challenges are also faced when states have to decide the granting or not of a legal status to persons that have found themselves in irregular situation with respect to their residency within the country. Our position as an institution is that in these situations there are often aspects that cannot be undermined and should be taken into consideration in favor of the persons involved, such as the duration of their stay in their country, their level of integration, the existence of children that were born or raised in the country. Because this is something we have tackled with the framework of the examination of complaints we have received of the office, I want to emphasize the critical role of the Ombudsman in protecting the rights of irregular migrants. The Ombudsman serves as an independent institution responsible for addressing complaints and overseeing the treatment of individuals in vulnerable situations, including migrants. The Ombudsman's role in this context is multi-sided. The Ombudsman can act as a mechanism to ensure that national policies on migration comply with international human rights standards. Whether it is the treatment of detained migrants, access to asylum processes, or the provision of health care and education, the Ombudsman can assess whether these rights are being respected. Irregular migrants often lack access to legal recourse or fair or retribution if they report abuses. The Ombudsman provides a safe avenue for examining complaints about mistreatment, whether that be of an abuse in detention centers, violations of labor rights, or denial of basic services. By investigating these issues, the Ombudsman can bring to light cases of human rights abuses that might otherwise remain hidden. Through recommendations to governments and authorities, the Ombudsman can push for more humane policies regarding migration. For instance, the Ombudsman can advocate for alternatives to detention, especially for vulnerable groups such as children and families. The Ombudsman can also promote family reunification or family unity, access to health care, and fair labor protection for migrants. Often, there is a profound mistrust between irregular migrants and the state authorities. The Ombudsman can serve as a mediator, providing migrants with a voice and ensuring that their rights are respected in legal and administrative processes. This role is especially important in ensuring access to justice for those who might otherwise remain marginalized. The Ombudsman, under its competence as an NPM, national preventive mechanisms, for those they don't know, also plays a key role in monitoring detention centers and border crossings to ensure that conditions are humane and in line with international standards. By publicly reporting on the state of migrants' rights, the Ombudsman holds governments accountable and pressures authorities to improve their practices. I find it necessary to also stress that to tackle irregular migration in a lasting and meaningful way, the international community must address these underlying issues. This means working to resolve conflicts, building more resilient economies, and taking urgent action on climate change. By addressing these root causes, we can help reduce the need for people to embark on dangerous journeys in the first place. Closing up, I would like to put on great emphasis in acknowledging that irregular migration, human rights, and border protection are issues that demand our full attention and our utmost compassion. It is a delicate balance, one that challenges us to uphold the rule of law, and one that respects the human rights of all people, regardless of their legal status. Thank you very much for your attention.
Now we're moving with the Q&A session. I think Mr. Ioannides will join us for that. Okay, thank you so much. I will start the other way around and then get back to you so that you can add any remarks if you want to the rest of the attendees. So I will start with Mrs. Gavouneli. Thank you very much for joining us from afar. I would like to ask you regarding the recent announcement by the German government, the new migration policies, including the border checks with all the neighboring countries. What's your view on that? Do you think that it will have any particular impact actually in Germany, in the flows? And why there were many statements and many reactions from other EU countries. What do you think? What are the implications for the European migration flows?
Thank you so much, and apologies for not being with you today. But it's really a pity that I missed this chance to see old friends. Congratulations, Minister. It's lovely to see you again, Maria. And I see the other two more regularly. So, the reason we have all been objecting to this announcement by the German government that there would be reinforced controls over the borders is that, in essence, this is a move that threatens to blow away the Pact on Asylum and Migration. The Pact is a joint effort, a combined endeavor, in which the European Commission has spent more than 8 years. It is not one document, it is actually 10 different documents, 10 different procedural issues, 10 different substantive issues. And that particular document also has, these particular documents rather, they also have particular roles entrusted to national human rights institutions, such as the Ombudsman of Cyprus and the Greek National Commission for Human Rights. So we are very much involved into that discussion. The problem is the following in very, very simple terms. The pact is based on an agreement. We're going to control the borders in a humane manner and in a manner that would respect human rights of applicants and all those who arrive in our shores. I will say a few words about pushbacks as the Commissioner has already indicated. But once a person arrives in Europe and gets through the system, then that person is allowed to move freely within the European market in the same way as any other European citizen. That means, in essence, that we trust each other to operate the same procedures and make sure that we offer the same level of protection. It is inevitable that, in spite of the fact that we have the same procedures, the level of living standards, if you like, is not the same throughout Europe. As a result, a person that would get the proper papers required in Greece, because that person has gone through the Greek system would sooner or later find its way to Germany, where the social provisions are better, where perhaps the opportunities for work are better, although I'm not so sure whether that is true these days. But at any rate, or perhaps they have family there, so they would like to end up unified with their friends and colleagues and cousins and brothers and sisters. So we see a flow of what we call secondary movements of people. The German government was always very worried about these secondary movements, but there's nothing that could be done because these secondary movements are actually lawful movements. So in an effort to address worries in the German electorate as to these kind of flows, but mostly about the fate of people who are already in Germany. I think that they have chosen to react in a manner that goes totally against the letter and the spirit of the pact. They have reinforced the internal controls. In essence, just by itself, that has no impact on the external controls that we have to operate with, we in Greece, we in Cyprus. But it is inevitable that if such a thing is allowed to continue, there would be a fallout effect, and there would be some kind of a continuation of that movement. I would be very curious to follow the developments in case we have increased movement of persons coming mostly from Lebanon now that the Middle East is blowing up again. If the German government would insist on this kind of additional controls and whatnot, or whether they would actually follow the provisions that we have all agreed on in the pact, and make sure that all the requirements are in place, all the reception centers operate according to human rights standards, and we, as national human rights institutions, are actually there to help. And 1 second more, just to say that our presence is not just a question of monitoring, of paying visits and going around and saying, what is this and why are you doing this or that or the other? But it is actually a very constructive approach, an attempt to help and facilitate and inform people and train people throughout the system. And it is actually in that context and in that spirit that the Greek National Commission has created already in these past 2.5 years a recording mechanism for pushbacks, for forced informal returns, where we just put on a form that is drafted in such a way as to be useful for the public prosecutor all credible information of possible incidents of that kind. That really helps us to understand whether such an incident has occurred or not. We are not the police. We're just taking the testimonies. But at the same time, we're now in a position to say that we have recorded something like 120 incidents in 2.5 years. That's a long way from the wild numbers that we have been hearing left, right, and center throughout. And that also sent a message to everyone, the government, the police, the Coast Guard, the authorities in general, but also the people involved, that there is somebody who's sort of looking over their shoulder, making sure that procedures are followed. Thank you.
Papastavridis, there are a number of countries that basically do not follow EU legislation and international law without having any particular impact. We know the case of Hungary, of Poland, there are several cases against, for alleged pushbacks against Cyprus, against Greece. So can a sovereign state protect its borders while adhering EU law? And is the concept of search and rescue still valid?
Thank you. Thank you very much. For the invitation. It's a great honor to be here, and thanks also to Aphrodite for inviting me. So yes, the question is, the answer is very simple. I mean, on the one hand, states have the power and the entitlement to protect their borders. It's a corollary to state sovereignty who are going to admit. But on the other hand, whenever someone has a lawful entitlement to asylum protection and to certain human rights, this person must be admitted to the territory. His or her claim must be assessed, and if don't found to have any entitlement, any complementary protection entitlement or asylum or refugee status, he or she might leave the country. Repatriate, as also the minister said. And this has been, both under international and EU law, I think it's very well intended. And so I think like pushbacks, personally, I'm very against this practice. Now, you asked me about the search and rescue situation, which is very, also here in Cyprus and in Greece, it's a very opposite issue. It is a humanitarian tradition, it's a maritime tradition, it's a humanitarian duty for every person at sea to be rescued. And this is no doubt on this. The problem, however, is that the rules that are there, the Search and Rescue Convention, SOLAS Convention, other IMO instruments, were built when there was, the idea of rescue was only for a vessel or a couple of people at sea. So now that we have all this, what we call mass rescue operations, more than, like in the Adriana incident, Pylos incident, more than 700 people on board of a vessel. So we need to somehow revisit this idea, this concept. And today we're in a state of flux. So there has been discussion in the European Union, IMO, on issues like what is distress, how can we conceptualize distress nowadays, what kind of operating procedures are we built on to actually address these mass rescue operations situations. What about disembarkation in third countries of safety? The issue of private stakeholders like NGOs that they are participating in search and rescue operations. All this, I think, are key to what is happening now in the Mediterranean Sea and what has been happening since 2015. But the pact does rarely address this issue, so I think we should revisit this situation.
Thank you. Now, Ms. Papachristodoulou, the same question for you. I mean, there are several other cases, there are several other policies that are quite questionable, like the asylum applications of Syrian nationals, its suspension, or the cases that are in the European Court of Human Rights against Greece and Cyprus. So what policy changes are required, and what responsibilities does Cyprus have when migrants are found at sea?
Thank you for having me here today, and thank you for joining us. So there is a lot to unpack in there, and I'll try to do so from a legal angle if time permits. So firstly, as the Minister has already told us about the measure of suspending asylum applications for Syrian nationals. As we know, this was an emergency measure due to the sharp increase of migrants arriving by boats in Cyprus, especially in April, where there were more than 1,000 people arriving by boats in Cyprus due to tensions in the Middle East. Now, we should also note that the pact, the new Asylum and Migration Pact that was adopted by the Council of Europe this year, also provides for a crisis and force majeure regulation, which allows governments to say that there is a risk of crisis in exceptional cases of mass influx of migrants, of third country nationals or stateless persons arriving. Now, what we don't want to see definitely with this pact is European states to linger on a regime of emergency to assert dominance over vulnerable individuals, victims of trafficking, and children. Now, many NGOs have voiced concerns over this measure that has been taken by our government. Members of the European Parliament have also expressed that this might challenge the right to seek asylum, both in EU law and international law. And in the case of Lebanon, there is mounting evidence that pushbacks are being practiced, so people are returned back to Syria, which is known as chain refoulement policy. And at the same time, there are questions about the living conditions in Lebanon, which raises again questions whether this is applicable with Article 3 of the European Convention of Human Rights, the prohibition of torture or cruel or inhuman treatment. Now, lately, again this year, we've seen that the European Court of Justice fined Hungary for breaking asylum rules, and they fined them with 200 million. So the fine was 200 million. So we definitely don't want to see this happening in Cyprus or Greece or in any other country, and definitely for how we stand in the international community and our commitment to human rights. Now, very briefly about some cases that are before the European Court of Human Rights pending. There is a case against Cyprus, the MNA versus and ZR versus Cyprus, which was communicated in 2020 and regards two Syrian nationals that were taken back to Lebanon by the Cyprus port authorities, even though they expressed their wish to seek asylum in Cyprus. And the submission claims that this is in breach of Article 5, the right to liberty and security, and of Article 3 because of the treatment of the coast guards in the boat, the refusal of the authorities to allow them to launch an application, and their return to Lebanon facing extremely dire living conditions with a serious risk again of being refought back to Syria. Now, obviously, this case raises a number of legal complexities. First one being the jurisdiction issue because those migrants were found at sea. This is a very perplexed issue in human rights law, and I don't have the time, I think, to be going into the jurisdiction aspect, but I should mention here that one very important case that was decided by the European Court of Human Rights is the famous MNS case versus Belgium and Greece, where the court found Belgium in violation of Article 3, between others, for returning the applicant back to Greece, where he couldn't, where he was exposed to dire living conditions, and there were deficiencies in the asylum system. Now, this year, according also to a global watchdog report by the Human Rights Watch, there were evidence that were saying that Cyprus have physically pushed Syrian refugees back to Lebanon. And we should also take into account that the European Court of Human Rights, when it hears cases, it takes very seriously NGOs' report. And these practices have also been denounced by the UN Special Rapporteur of the Rights of Migrants and the Council of Europe's Commissioner for Human Rights. Now, Cyprus to date has not been confronted to court. However, all this information leads us to the fact that Cyprus might arguably be practicing pushback in this policy to control in its efforts to control migration. And very briefly, because Akis has already touched upon the duties that states have towards people at sea. So these duties emanate from a variety of fields of international law. They emanate from the law of the sea, the duty to render assistance at sea. We have international refugee law, the non-refoulement, not returning someone back where their life is at risk. And we also have human rights obligations. For instance, the duty to render assistance at sea, we can say that it is a corollary obligation of the right to life. So certain positive and negative obligations arise, but of course we have the issue of jurisdiction. And what is clear is that the ECHR in 2012, in one of its most famous cases regarding migration by sea, in the Hirsi-Jama versus Italy case, decided that Italy was in breach of Article 3 of the ECHR because they have returned those migrants back to Tripoli, where they were coming from. So the Italian forces took them on their boats and took them back. and this was in violation of Article 3, and they also condemned Italy for drawing cooperation agreement with Libya that was in breach of the violation of the human rights of the migrants. Now, I think in a nutshell, these are the obligations that states have, and just to finish up, like policies that we draw and are aimed at tackling migration flows should incorporate an effort to minimize unintended side effects such as foreseeable deaths at sea and refoulement practices, and they should operationalize the protection and the safety of people at sea. But as already touched upon, we need solidarity measures in order to be able to tackle massive influx of migrants that are arriving irregularly, either by sea or through the buffer zone. Thank you.
Very much. And now, Mr. Ioannides, I don't know if you want to add anything to all these cases that were mentioned. I would like to focus a bit more on the statements that have been issued both by UNFICYP and UNHCR accusing Cyprus of pushbacks in the Green Line, and Cyprus finds itself in the defense on this issue. So how do you respond to this, and how do you plan to proceed with this case?
Allegations or facts. I'd like to set the record straight. The government of the Republic of Cyprus does not perform pushbacks, either at sea or at land. And at land, actually, it's impossible to perform pushbacks. Because there's no operation pushing migrants over the border. On the Green Line, not a border. Okay. You hear me now? Yeah, better. So as I was saying, it is not possible, using the term pushback when it comes to the green zone, it's not accurate. There's not a border. And of course, the Cypriot authorities do not push migrants into the occupied areas. What we're doing is actually applying the Green Line regulation, which stipulates that we are under an obligation to monitor effectively the Green Line so as to combat illegal migration. So I'd like to make that clear. And of course, we also need to bear in mind that sometimes even the European Court of Human Rights itself construes and applies human rights rules in isolation without taking into account any other pertinent rules of international law. In other words, they do not apply the systemic integration principle, which is a fundamental principle of the law of treaties, envisaging that when it comes to the application of international law, we need to take into account all the relevant rules in a case. So we cannot just apply or invoke human rights rules in Cyprus, for instance, without taking into account the application of EU law, the application of international humanitarian law applicable because of the belligerent occupation of northern Cyprus. So the rules of EU law and IHL should inform the interpretation of human rights law. It's a system. International law is a system. It's not about isolated rules. It's not black and white. Not that, of course, migrants do have human rights, but we need to take into account the whole context. That Cyprus under belligerent occupation, that Turkey at least tolerates the transit of migrants through its soil into the occupied areas, disregarding its own obligations according to international human rights law. So, taking all those factors into account, the outcome, the conclusion is not that simple. We need to examine all those rules and factors before reaching conclusions as to whether State A or State B or Cyprus violates international law. We're a law-abiding state. We've been a victim of international law violations, so we take that very seriously. And as I said earlier, the Republic of Cyprus does not perform pushbacks at sea, and it's impossible to do so on its terrestrial land, because there's no such thing, there's no border, we don't do that. Thank you.
Are there any, I have time for basically one question, if there are any questions from the audience. Basically, your deputy president, there cannot be legal aspects or agreement that are immigration. I believe that you asked the question, like Cyprus is a small country has little population, very different profile from other European countries which could accept more immigrants, which could provide them for job or something. Cyprus is very small, and we can accept certain amount of people who need to be protected, but still people are coming and there is issue. So European Union cannot treat and apply pure law and regulations and agreements. So is there any discussions and challenges how to treat that? I've heard of the program that some immigrants might go to another countries which are willing to accept them, but a part of that, is there any other policies or improvements or something to take into the consideration demographic and economic factors of like Cyprus has? And which countries would that be? That would be interesting. Which countries would be willing to accept migrants from the EU?
I've heard of the program that there will be some people moved to another European countries. If it's a case, really?
For the question, indeed, as I was saying, the capacity of Cyprus to host more migrants is overstretched already. Asylum seekers and recognized refugees amount to 6% of our population, way above the EU average. So in order to maintain a viable asylum system, and that's what is at stake, to have a viable asylum system, because otherwise we won't be able to offer adequate protection to those entitled to international protection. I'm happy to say that the Commission and other member states, especially the Commission, show understanding as regards the situation in Cyprus. We've entered into a very fruitful dialogue over the last months in order to address this matter together. So they've realized that Cyprus or other frontline states cannot do that by themselves. So we need support from the Commission, from the European Union, and they're ready to provide support. You're aware of the discussions, the internal discussions in the EU with respect to solidarity and external border controls. So there's a shift in EU's policy towards more comprehensive policy. They do understand that frontline states need support in order to deal with migrant flows. So it is important to stress that there's been a shift in EU's policy. They show more understanding. The pact is also a sign that the Commission, the EU, is willing to address this matter in a comprehensive and effective way. So I think the pact, the implementation of the pact, will offer many solutions to member states, especially frontline member states. And we look forward to working with the Commission and other member states in order to successfully implement this pact. Thank you.
Thank you. Thank you very much to everyone who has been joined me on this panel. Thank you for joining us.